Welcome to the 8th edition of World Intellectual Property Forum.
A very warm namaste to everyone present and listening, and a big thank you to the organizing team of WIPF 2020 for bringing us all together, at least virtually through these viral times. I am Sonal Mishra, working as an off-counsel with the litigation department of LS Dawar and Company. With me today, I also have Ms. Aastha Sharma, a patent attorney with the life sciences wing of the firm, and Mr. Chirag Bansal, who is part of the team handling LS Dawar's patent portfolio related to electronics, communications, and software. Although it is not the time of the year when the patentees or the licensees are required to furnish a statement in Form 27 describing the extent of commercial working of the concerned patent in India. However, it is only pertinent that we discuss the requirement, or I would say an additional requirement on the patentee, since a much awaited revision to the existing Form 27 has come into effect earlier this October. So filing of commercial working statement under the Indian patent laws is such a peculiar obligation on the patentee. It's a requirement which must be met annually by the patents, like annuity payments, although it doesn't involve any costs. A provision of the Patent Act or the Indian Patent Act empowers the controller to direct any patentee or licensee to furnish a commercial working statement. A follow-up provision in the Act takes it a step further by imposing an obligation on all patentees and licensees to submit commercial working statement. Now, another proof which establishes this requirement as not only being peculiar, but a risky one, or I would say a tricky one for the patentees, is a 73-pager document containing suggestions or feedbacks from the stakeholders across the globe on the details which must be required to submit in Form 27. Now, these suggestions or feedbacks running into 73 pages were submitted by the stakeholders upon invitation from the Patent Office a couple of years back. Now, gladly, the Patent Office, with the revised form, has incorporated few of the suggestions mentioned or voiced by these stakeholders. So today we shall look at the provisions, or particularly the revisions made to Form 27, aspects that have evolved, suggestions on filing out the details required under the new Form 27, the positives for the patentees and the licensees, considerations in submitting the form, and the impacts that a submitted commercial working statement could have during a patent litigation. So let's get started by looking at what has stayed and what has gone after the amendment. So now, the repealed Form 27, which is now revoked, required the patentees or the licensees to submit an exact quantum and value of the patented product in rupees manufactured in India and or imported from other countries by furnishing country-wise details. So now the requirement of submitting exact quantum and value of the patented product is being done away with. Now we would only need approximate value or revenue from a patent or related patents manufactured in India or imported from other countries. Now, what does it mean? It's not only approximate value or revenue which is now required, but also the quantum, the number of units of the patented product which is being sold is also done away with. So only approximate value or revenue is required and no exact value, and also the exact quantum or the units of the patented product is also not required. The another important thing, earlier the Form 27 obligated the patentees or the licensees to submit country-wise details of the product which is being imported from other countries. Now, those country-wise details need not be submitted anymore. Also, the current form or the revised Form 27 allows the patentee to include all those related patents which are incorporated in a single patented product. So which this provision was earlier not there in the repealed Form 27, and it finds applicability and sense more in computer related technologies, telecom and communications, where it is rare to see that a particular patented product involves only one patent, and in all practical cases it involves multiple patents. So this is a significant change which has been done in revised Form 27. The other one relates to the details of licenses and sub-licenses granted during the relevant calendar year. You would appreciate that the details related to licenses and sub-licenses are confidential in nature, and the applicants or the patentees are wary of providing such details in the Form 27. So gladly, a very heartening amendment has been done, and this particular requirement where such confidential details pertaining to licenses and sub-licenses have been removed. Now, the patentee need not provide any details related to any license, or the details of the licensees or the sub-licensees are not required anymore. Another requirement, which I would say is a very onerous requirement for a patentee, where they were asked to submit whether public requirement has been met partly, adequately, or to the fullest extent at reasonable price. What does it mean? The patentee were asked whether the public requirement from the invention has been met. It is a very difficult requirement on the patentees. It is very harsh on the patentees to assess this particular information or this kind of information to be submitted every year. So even that requirement is gone. The other thing, to bring in line with the fiscal policies of most countries, the calendar year has been done away with. Now the assessment will be based on the financial year. So earlier, it was required to be submitted by 31st March of the following year. Now we need to submit the working statement every financial year within 6 months. That is by 30th September of every year. So that is why I said it is not the time of the year to submit Form 27, but it is pertinent in light of such important revisions, which is of interest to all the stakeholders across the globe. And so it is pertinent that we discuss this provision today. Also, since this requirement, whether public requirement has been met partly or adequately or to the fullest extent has been removed, it means if by way of Form 27 we suggest that the patent has been worked, we would not be required to show sufficient working, which was the requirement. So with this relaxed norm, it appears that if we demonstrate that the patent has been worked, a sufficient working need not be disclosed. So it's a form which fits all the technology. So it's a one form which fits all, which was not the case earlier. So with this, we'll move to what could be the potential risks associated with non-compliance or even partial compliance of the obligation to submit commercial working details. Now, if we do not submit commercial working details, or even if we partially comply with it, what could be the repercussions, which is envisioned in the Act? So, it may invite an application from any interested person for grant of compulsory license on patent at any time after the expiration of 3 years from the date of the grant of patent. So the first 3 years You need not provide the working statement. You can just file a nil working statement or a non-working statement. But if certain requirements mentioned in the Act are not met, it can invite an application for the grant of compulsory license. So this is one, I would say, a penalty associated with where partial or full rights may be done away with or may be lost by the patentee. Now the another thing is if there is a failure or refusal to furnish required information, it may attract fine up to Indian rupees 10 lakhs or US dollar 14,000 or 13,000 euros or Great Britain pound 11,000. So it's a fair amount of fine which may be imposed if we do not furnish the information which is required under Form 27. Now this penalty is further enhanced. Now it goes beyond the fine, and there is an imprisonment up to 6 months if there is a falsified information which has been furnished, or if the information is furnished with a fraudulent intent related to working of patent in India. So if any information is hidden, or if any information which is provided is intentionally wrong, you may also end up in prison along with fine. Now the annual report, the latest annual report, which was published by the Indian Patent Office in 2018-19, which has the data for 2018-19, states or discloses that 51,104 Form 27s were received, out of which only 14,277 patents were reported as working. So which is only around 30% were reported as working and 70% were non-working. So this is the stat which was shared by the annual report, which has the data of 2018 and 19. So now, although these issues, or I would say the penalties, are associated with non-compliance or partial compliance of the commercial working statement, but how much they have been implemented, how many times they have been invoked? Very less. There has been only one compulsory license which has been granted in India so far. So there have not been many compulsory licenses which have been granted. There have not been many compulsory licensing applications which have been filed against the patentees. And the penalty provisions lie in the patent statute in the moribund state, which means the penalty provisions have never been enforced, have never been invoked by the controller. So although these provisions are there in the Act for non-compliance or partial compliance, but they have been rarely invoked or not invoked at all. So with this, we'll move to the importance of commercial working statement and how it may also come into play if a patent is litigated. Now, the courts have made very interesting observations underscoring the significance of commercial working statements. And a few of these observations are: periodical statements as to the extent to which the patented invention has been commercially worked in India is mandatory under the Act and must be furnished. So it's a mandatory requirement which was observed by the court in this particular judgment. The another very important observation which came out from the same judgment was that if you merely obtain a patent without commercially exploiting the same, itself will not be a ground to prevent others from doing the same business. If such scenario is allowed by this court, it would lead to serious consequences and also affect the development of the economy and new inventions. What does it mean? So it means if a patent has been granted to you and you have not commercially exploited the same, and then you go on to enforce your patent against the competitors or the alleged infringers, it would not be entertained, they are saying. You can do that, but certainly it will go against you when you enforce your patent rights, and when, especially if you have not commercially exploited the same. Now, another important, I would say a very important another important role of Form 27, especially in pharmaceutical and chemical related patents, is that a patent working statement has a role to determine novelty of a patent. particularly in a Marcus style claiming in a genus and species patent where coverage or disclosure of a component may be equated to working, meaning if a patent has been worked in a product, it would also imply that the patent has been covered or disclosed in that patent. So that what does it mean? It means that whatever admissions we have made in Form 27, it will be binding upon the patentee. If a patentee has mentioned that a patent has been worked in the particular Form 27 statement, it would mean that the patent has been disclosed or covered in that particular patent. So you cannot go back and say that the patent is not being covered by that particular patent if it is admitted that it has been worked. Now, the another important impact of 427 is Form 27, my correction, is in determining injunctions and damages during a patent suit. So, in one of the very important standard essential patent case filed by Ericsson against the Indian handset or Indian mobile manufacturers, a party argued that the SEP owner's royalty offer was non-frank, that is non-fair, reasonable and non-discriminatory, since in Form 27 filed with the Indian Patent Office, the right holder disclosed lower rates. So what does it mean? It means it will have an impact on the amount of damages which you are claiming. If you have disclosed lower rates or higher rates, maybe the court will look at Form 27 to decide the amount of damages you must get. So again, that has an impact when a patent is being tried or during a patent litigation. So again, the court has further extended and said in that judgment that the information submitted in Form 27 in India by the patentee can be used in support or against such claim of damages before the court. The other important observation made by the court was that the approximate information of a commercially worked patent can assist the patentee in substantiating its prayer before the court for injunction and or damages in the suit for infringement. So what does it mean essentially? It means that during a patent trial, the claim for damages or injunctions can also be affected, which means that the substantial details submitted in Form 27s would in all likelihood be consulted by the courts while deciding the quantum of damages or injunction application made by the applicant. So it only suggests that Form 27s are a serious business and it's an important issue. So we'll move on and look at the revisions made to Form 27 that we have already seen. And now Ms. Aastha and Mr. Chirag will take us through a few exemplary Form 27s which could now be submitted post-revision. The exemplary forms shown are curated based on the commercial value the patent may carry for the patentee. So I would request Mr. Chirag to share his thoughts as to how the revised form will shape the strategy for filing the commercial working statement, particularly in the areas of communication technologies and software. Chirag, over to you.
Thank you, Mr. Mishra. Greetings, everyone. I will certainly walk you through concerns of the stakeholders regarding the commercial working
be louder,
statement.
please.
Greetings, everyone. I will walk you through concerns of the stakeholders regarding the working statement in India, format of new Form 27, and possible working statements for patents of different commercial values. Next slide. So this is the format of the new Form 27, which we need to submit by September 30 every year. Here, the patentee has to furnish the information whether the patented invention is worked or not. And if yes, with possible reasons, how much is the revenue or value occurred in India to the patentee, and in case the patented invention is imported into India, patentee is supposed to give a brief description about the same. And if the patented invention is not worked in India, then the patentee has to give the explanation why it has not been worked or what steps has been taken in this regard. Next slide, please. So these are few of the concerns of the stakeholders raised with respect to the previous Form 27. One of the major concern was it was very difficult to determine the quantum and value of the patented product. Earlier, it was one of the requirement to submit the exact value and quantum of the patented product. Also, previous Form 27 was based on the presumption that one product is equivalent to one patent. However, such a model is non-existent in communication sector. Rarely we see a product which is based on a one patent, especially in telecommunications. One product includes or contains or is based on many patented inventions. Also, in the previous Form 27, there was various ambiguous terms, as for example, whether the public requirements has been met partially, adequately, or the full extent, also at reasonable price or not. All these terms were very ambiguous and there is no definition for such terms. It was also one of the major concern of the stakeholder that unlike many major jurisdictions, they do not require submission of Form 27 or working statement, although this is the requirement in India. All these concerns related to quantum and value, one patent, one product, and reasonable price has been removed. However, the patentee is still supposed to submit Form 27 every year. Now we will be discussing possible working statements for patents of very or different commercial interests. So we have a patent of high commercial interest, patents having high risk of infringers or high infringement risk. Then we will be discussing possible reasons or possible working statements for medium commercial interest patent and low commercial interest patents. For patent having high commercial interest, we strongly advise that to reveal the most realistic numbers, as for example, sales figure before the Indian Patent Office, since the Form 27 during the litigation can have a major impact while determining damages, and therefore for the patents having high infringement risk, we strongly advise revealing the exact figures or the most accurate figures related to the sales number of the patented product being imported in India. Now we will be discussing the possible working statements for patents having high or medium commercial interest values. And for those patented products for which revenue data is not available, we strongly advise, in case the revenue data is not available, while submitting the Form 27 or the working statement, highlight the field of invention. And in case the invention is related to the software or the field which require interoperability of the infrastructure, then mention all these things in the working statement. Why it is hard to provide exact numbers? Many times this happens in client server based invention, where some part of the invention is worked in India and some part is outside the India. This is one of the example where the sales figure or the data was not available for the XYZ Limited. So XYZ Limited gave a brief description about the domain in which the company is working, how old the company is, how many R&D facilities or the patent the XYZ has filed in India or globally. Also, XYZ has not provided the details or the sales revenue for the patented product. Instead, the XYZ has provided the sales figure or the revenue for the entire year of the whole company. Also, at last, next slide, Mr. Mishra, please. At last, the XYZ has highlighted the field of the patented invention for which XYZ is filing the commercial working statement, and also stated why it is close to impossible to provide the information related to the quantum and revenue occurred from the patented product. So this is one of the examples, one of the possible example where the patent having high or medium risk, and in case where the sales figure or the revenue or the data is not available, then this is the one of the example where a reason is being provided to the patent office or may be provided to the patent office why the applicant is not able to give out the exact data. Now we will be discussing the possible reasons for non-working of the Now we will be discussing possible reasons for non-working of the patents. The applicant, the patentee or the licensee may provide a statement that the data is not available and will provide the same when specifically asked by the controller. Also, the patentee may provide that we are still accessing the commercial and technological aspect of the patent in India and negotiating marketing and distribution of the patents with related parties. Also, the patentee may provide a possible statement as for example that the company is exploring Indian market for determining need and will take the appropriate steps in near future. Also, as one of the possible example or possible statement, the patentee could provide that patentee is working further on the product to make it economical in accordance with the Indian market conditions. Now, Ms. Aastha will lead to the working statements concerning the pharma sector. Thank you.
Thank you, Chirag. Thank you, Chirag. I would now request Ms. Aastha to add further light on the subject with a special focus on the pharmaceutical sector. Aastha.
Thank you, Mr. Mishra. Greetings, everyone. So I'll be walking you through the working statements in the pharma sector. As it has been mentioned, the utmost importance of working statements. Similarly, in pharma sector also, the working statements are of crucial nature. The working statements have to be filed for every granted patent, whether it's of being high commercial interest, medium commercial interest, or low commercial interest, or it has not been worked at all. The working statement has to be filed. However, the details may vary depending on the importance and the working of the patent. So suppose the patent is of high commercial importance and have a potential infringement risk. In that case, it is advisable to provide the closest value of the revenue which have been generated in India. The closest value or the realistic value. It may not be the exact value, but the approximate value should be provided when the patent is of utmost importance. Now, if the patent is of medium importance or it has not been manufactured in India or it has been imported to India, in that case, the revenue, instead of providing the realistic value, the patentee or licensee can provide the sales figure, market share, revenue figures from annual statement or other public sources. However, if the patent is of low importance, the patentee or the licensee can only mention that it has been worked and that the further information may be provided when the controller is asked. It has been observed in last few years that in pharma sector, few suits has been filed, and one of the ground for revocation was Form 27. The competitor have closely monitored the working statements filed by the pharma companies. And one falsified information or one careless mistake in working statement can lead to the infringement suit or any other litigation matter. So it shows that now the working statements has become very important for the patentee or the licensee. Therefore, in order to bring more clarity in Form 27, the said form has been revised recently and the same has been reproduced for your reference. The form has also been shown by Mr. Chirag. Here, the revenue has been, now the revenue has to be given in approximate range instead of exact range. Now only the brief description has to be given instead of mentioning about how it has worked adequately or reasonable price. Instead of all those things, only a brief description about its working has to be given. So now I'll be moving towards the examples of high value patents, low value patents, and medium value patents. So this one is regarding high value patents. So this is the box where you need to mention if your patent is worked. So first point is regarding approximate revenue value accrued in India to the patentee, licensee furnishing the statement from patent number where the working is through. In this point, you have to mention the patent number and then you have to mention the approximate value. If your patent is of high importance, we advise you to provide the closest figures of your product. And it is also advisable in a patent which is of a Marcos structure to mention the product name or the brand name to which it has been commercially exploited. Because as Mr. Mishra has also mentioned about one of the cases where the disclosure and coverage has been questioned. It is because the species and the genus patent, both patents have the working statement of a same product, which was later questioned at the court. Therefore, the lesson which we got from such suit is while submitting Form 27, the product name has to be given and I would say the exact, not the exact, but the approximate value which is closest to the exact value should be given along with the product name. And if the quantum, if possible, should be given in case of high value patents, because when the potential risk is high, we would not suggest to take you any risk regarding any of the falsified information. We would suggest you to give as much information as possible. So this was one of the patent where the patentee has given the product name, the quantum and the value, and has also given the second brand. So for this kind of a patent, it was a Marcos patent and there was thousands of compounds which were claimed under it. However, only 2 brands came to commercially exploitation. Those 2 brands were mentioned in the working statement and their values and their quantum have been reported while submitting the working statement. And it could be considered as a good practice while submitting a working statement. Similarly, in this case, again, there were 2 products which were brought to the commercial exploitation, and these 2 and the manufacturing quantum and the value generated from the products has been mentioned. So it can be seen from these examples that these patents were of utmost importance to the client, that's not to the patentee or to the licensee. That's why they have given the detail as much possible they could give in a working statement. Now we would move to high medium value patents. Suppose the patent is not of that high importance. In that case, and sometimes it happens that the manufacturing is not able to be conducted in India and has to be imported from outside India. Now in that situation, you cannot provide the actual revenue which is generated in India, or maybe you could not provide the proper quantum. In that case, it is advisable that you just highlight what the patent is about and what is the technical field to which it belongs. And then you can give the reason that why it has been imported to India. There could be a reason that there is no manufacturing facility available in India, or maybe there are some products which requires a particular weather conditions which might not be suited in India. So there could be multiple examples which you can give while filing a working statement for medium value patents. One of the examples for medium working patent is, in this case, the product was not manufactured in India. However, it was imported from other country, which was Sweden. So they have mentioned from where they have imported, and they have given the reason that there was limited market potential for this product and the patentee lacks manufacturing capability. Therefore, this product has been imported to India, and they have also mentioned the sales recorded regarding this product. So this could be one of the this could be considered as one of the good practice when you consider that your patent is not of high importance, and then you can give such kind of descriptions while filing your working statement. Now, low value patent. So sometimes it happens, like in the field of pharma sectors or in the field of chemistry, you would know that it takes time to get a grant. Between that, there are a lot of products which come into the market, and there is continuous research and development happening in this field. You never know which competitor is going to launch which product, which patent has been filed, and by the time it gets granted, you realize that there could be more development to this product, and we could add something better to this product. In that case, such patents become low value. In that case, you might just mention that your patent has been worked. However, you may provide the information to the controller when the controller asks. So only mentioning that the patent is worked and you would furnish the exact approximate value or the revenue on the directions of the controller would suffice the requirement when you have a low value patent. So now there are cases in especially in pharma sector and life science domain that most of the patents might not work. What I mean from might not work is that suppose you have developed a pharmaceutical product, and by the time it gets granted, you realize that the efficacy shown by this product can be increased by adding some modification or by adding some groups variants. In that case, you don't want to commercialize the product patented and you want to continue with the research and development. So this could be the reason you can give if you find that your product can be of much more importance if it is modified. So in that case, you just mention that your product is not worked because it requires research and development. Now, the other reason which you can give, not every product has a market potential. So there are some product which, like by the time it gets granted, you realize the market potential is very limited, and the manufacturing capability which in India is also lacking. In that, you can give the reason that the demand of the product is insufficient to justify the production. That's why you have not worked your patent. This could also be the one reason. Other reason which could simply mean the better opportunities. Sometimes what happens that the product, the time you realize that this product is of low value or there are much better products in the market, you might not need to work that patent. So you can just mention that you are looking for better opportunities. The other reason which you can give, in pharma industry, everybody knows that when you want to launch a pharma product, you requires a lot of authorizations and a lot of approval. You need to perform clinical trials, preclinical trials, a lot of data of safety and efficacy has to be submitted if you are launching a pharma product. In that, so there are sometimes what happens, the authorization, the drug regulatory needs more data and you require more time. So it's not possible for a pharma company to provide working statements straight after 3 years from the grant, because sometimes the creation of the data of clinical trials, pre-clinical trials, human trial phase, and the approval takes much more longer time. In that case, you can simply mention this statement saying that in the pharma industry, there are many new inventions coming under development all the time. An invention needs many years of development before it can be worked. Example, several years of pharmacology, toxicology analysis, several years of clinical trials, and or several years of regulatory administrative process to approve the product. And this could be a very good practice or a valid point for the non-working of a pharma product. And the next reason you may give that the production side in India is not according to the customer need, or there are no customers of the product. So this could also be one of the reasons for non-working. Here, on this note, I would like to ask Mr. Mishra to conclude the presentation.
Thank you, Aastha, for particularly highlighting the future Form 27 would look like, and also the requirements or the way the Form 27 is filed today, and the way it should be filed in the future. So that was some useful insight on the pharma chemical sector. So I would also like to add a general footnote to our discussions that since we are going through a pandemic, so even if 3 years from the date of the grant of the patent has concluded, for this particular year, we can still choose to file a non-working statement, because there is a provision in the Act which suggests that if there is a national emergency, the working can be skipped. The working requirement can be skipped, which means that a non-working statement can be filed with the patent office, even if 3 years from the date of the grant of the patent has expired. So I just thought I will add this, given that we are going through difficult times. And so owing to pandemic and the provision in the Act, we can skip filing a working statement for this year, for 2020. So you would appreciate that Form 27 is a serious business. While the penalty provision puts a risk on the patentees, its impact on the litigation also makes it a very important strategy component of an organization desirous of maintaining the patent by paying the maintenance fees in India post grant of the patent. So it has impact across the board in the life cycle of a patent. So the revised Form 27, we have looked at various aspects of the revised Form 27. We have seen what are the present requirements and what should be the future requirements or the future style of drafting a Form 27. We have looked at all those aspects. But the Form 27 leaves certain aspects ambiguous. Or I would say, although the Form 27 leaves certain aspects ambiguous, but certainly the revision is more sensible and directed towards reducing the excessive burden on the patentees or the licensees. Importantly, and very importantly, across all technology and pharmaceutical domains. Earlier, the Form 27, which was in vogue in practice, appeared as if it was only prepared for the pharmaceutical sector to attract compulsory licensing provisions for the pharmaceutical sector. And it ignored the practical challenges of the sectors such as communication technologies and computer-related technologies. So that seems to have been done away with. And now we have a one form which fits all. Although there are ambiguities, although there are things which must be removed, which must be omitted, but we'll have to wait for another revision for that. But this is just a very welcome move, I would say. So with this, the panel will be happy to answer any questions you may have on the concluded discussion. Thank you.